morning, my beautiful babes and babes. I'm your resident active advocate, and I'm frustrated, which is a combination of flustered and frustrated, if you couldn't tell, because I have been advised to try and fiddle with the timeline in my book, and it's not working out. So, alternative to pulling out my hair, I will be working on different parts of my book today, and going back to this after I have consulted with my lovely consultant, who is, need I remind you, the most spectacular human being to ever live. And not only is she my lovely consultant for these videos, but also my lovely consultant for my book and pretty much every other creative endeavor I've ever gotten into. That's not exactly true. But okay, today, to get on topic, I would like to finish off our series on bioethics by talking to you about the 3 primary rights that a patient has going into the medical setting. This does not apply strictly to people with disabilities. This applies to every person going into the medical setting. So, under Canadian medical law, at least this is Canadian law, I'm not sure about other countries, but you have the right as a patient to personal autonomy, to beneficence, and to non-maleficence. All right, so remember those 3 things, but I will describe each in some detail. Personal autonomy means that as the patient, you have the right to make your own decisions concerning your own health. You cannot be legally cajoled into making one decision versus another by any third party. You can seek advice, absolutely, but inevitably the decision is up to you. The second right to which you are entitled is that of beneficence, which falls more to the practitioner who is working with you, because the role they play there is to do well by you, is to do good for you. So let's say you come in to a doctor with a broken leg. It would fall under the role of beneficence for them to bind up that leg, to cast that leg, to maybe give you a set of crutches to help you get around until that leg heals up. It also falls to them to have regular checkups with you to make sure that you are progressing towards the path of healing, right? Non-maleficence, in contrast, it sounds like a very similar thing, but non-maleficence is the mandate to do no harm. This is the basic mandate behind every version I have ever encountered of the Hippocratic Oath, which actually originated in ancient Greece with the father of modern medicine, Hippocrates. And the oath ostensibly is to say, as a doctor, that you will do no harm by your patient. Now, when it comes to that, let's stick with the broken leg example. It would be not to exacerbate the injury in any way, or at least not to intentionally do so. If you knock their leg accidentally while you're binding it up, that's not your fault, but it is still on you as the practitioner to make sure that you act responsibly by your patient, not to further any harm that has already been done by way of injury or disability or that sort of thing. When, however, it gets into wider bioethical questions, these 3 things can be very difficult to maintain and to maintain consistently. For example, as we were discussing yesterday, euthanasia, and the day before when we were discussing medical assistance in death. How do those fit into the model of non-maleficence, for example, not to do harm by your patient? Medical assistance in dying, I would argue, does still qualify as a non-maleficent practice, in that you are not ending the person's life per se, because their death is already reasonably foreseeable within, a short enough span of time. Whatever condition they have come in with will inevitably kill them. Medical assistance in death, therefore, is a practice not in shortening life, but in shortening pain. And that is the very important both legal and medical distinction that has to be made. Euthanasia, in contrast, because it removes, to some degree at least, the element of autonomy, because euthanasia can be performed by a practitioner who does not necessarily have your permission, or, who may have the permission to execute euthanasia by way of your power of attorney or your family or other practitioners. That, I would argue, is a maleficent practice, in that they are removing the sense of autonomy from the equation. They are removing your right to personal freedom and personal choice from the equation. That is fundamentally, or one of the fundamental ways in which euthanasia, as we discussed, differs from medical assistance in death. So it's very important to understand the difference between beneficence versus non-maleficence. But the one on which I would like to touch now is personal autonomy. Personal autonomy is sort of a shaky subject, in that, sure, it can apply to people, quote, like you and me, people per se who do not have an intellectual disability of any kind. This also applies, by the way, to children. There is, in the medical field, no, quote, legal age at which a child can or cannot consent to a procedure being done to them, to an operation being done to them. There's no legal limit for that, because that all depends on the child's degree of understanding of the ramifications of their decision to go through with a procedure or not. So, for example, if the child were to require, this is an extreme example, but a heart transplant, depending on how old that child is, they may or may not understand what exactly that entails. Transplants have, with our current technology, a bit of a habit of going wrong sometimes, not all the time. It needs to be understood that this could lead to further harm. This could even lead to death, but not necessarily. So it needs to be very carefully and very surely laid out for the child by their medical practitioners and by their advisors and by their parents what could and could not happen with any given procedure, because the child still has the right to decide for themselves. It's not going to be the case, usually, that a child under 12 will make the decision for themselves. That usually falls to their parents. But that's not a matter of legality, that's just a matter of logistics, because a child of 12 and under is probably not going to understand the ramifications of a much larger medical decision that could affect them for their entire life. However, when it comes to the autonomy of, say, a person with an intellectual disability, who will probably never have the capacity to understand the ramifications of their decision, to whom does the right to autonomy actually fall? Theoretically, it still falls to the individual in question, but because they may not be capable of making decisions for themselves, that would likely fall to their caretakers, to their power of attorney, to their parents, so on and so forth, and also to the medical practitioners involved in whatever sort of case is going on here. Autonomy, however, cannot be removed. It is an inherent human right in the medical field, so it has to be understood that what are called best practices should be executed in these cases. I spoke several days ago of the case of Ashley X. Ashley X was a child with a very severe intellectual disability, and on her behalf, it was decided by her parents and by the medical community involved in her case to go through with certain procedures, which nowadays, and even at the time, were viewed as both unnecessary but also maleficent. They did not necessarily lead to the child's good. And if you go back, I did age restrict this video, but if you go back and watch my video on Ashley X, you'll understand why I say that. Medical autonomy is extraordinarily important because a violation of human rights that comes down to the medical basis can fall into the category of eugenics, and we don't want to get into that in the medical field. There are kind of, shall we say, quote, iffy areas where that sort of understanding can be flouted. I gave also the example of the elimination of Down syndrome in I believe it was in Norway, where they are attempting to carry out this practice. That, to me, is a form of eugenics because not only is the technology not entirely certain yet for the detection of the chromosome abnormality, not only is that technology not entirely certain for one thing, but for another, you're also eliminating or attempting to eliminate an entire people group. I don't agree with that practice. You know, I'm not scientifically literate enough, and I'm willing to admit that I am not scientifically literate enough to fully understand whether this decision on the country's part, on the part of the people in the country, you know, who provide the social pressure for women to be tested before having a child and then to abort the child if they show tendencies towards Down syndrome. I'm not medically literate enough to say whether that will, quote, work in the long run. I don't think you can fully eliminate a disorder such as Down syndrome because it relies on your genes going, quote, wrong. It doesn't rely necessarily on heritability. It doesn't rely on whatever race you belong to. It doesn't rely on a gender or sex factor. None of that. So this is a eugenic practice in that it will never conclusively end. That's a major problem. But even for eugenic practices that will definitely bring an end to certain things, such as life, such as fertility, such as, heck, if the technology goes far enough, such as certain disabilities, you know, blindness, deafness, intellectual impairment, these sorts of things that we're all subconsciously afraid of and therefore want to eliminate. How far should those practices be permitted to go? And does the person with the disability have the say of yes or no? I want this done. I do not want this done. Personally, if you said to me that you could make me fully sighted, I would tell you to back off because this, while not intrinsically my identity, is part of my identity. And it's a very important part of my identity. I would not be who I am. I would not have the friends I have if not for what is, quote, wrong with my eyes. I don't think it should be left up to any external standard whether a person is, quote, wrong or, quote, right to be living as they are. The medical right to autonomy, therefore, decides or has the person decide for their own, on their own behalf, whether or not they consider themselves to be, quote, wrong or, quote, right. And I think it's very important that we make those decisions for ourselves as individuals without any external pressures or influences. If we don't have that right, then can we really call ourselves independent? Personally, I don't think so. That is, in my mind, among the most important human rights, not just medical rights, but human rights. The right to personal responsibility and to independence. Because without those, we don't have very much going for us. We just have other people controlling our lives, and that's not healthy for anyone, let alone for people with disabilities who are already marginalized and looked down upon for, quote, not being independent. Thing is, we can't be if we're not given the opportunity. So, while I'm not begging, I am not asking, I am saying, give us independence. Because we're taking it. All right, that concludes our series on bioethics. And next week, I will be beginning, a series on disability as portrayed in Disney feature-length motion pictures, so Disney movies, all the way from Snow White up to modern times. I have some research to do. I'm going to touch on the major ones anyway, the major ones that include some kind of disability theme in them. And yes, Snow White does apply here. And this is going to be fun for the whole family, and I am also going to ruin some childhoods. 2 thumbs up. Have fun. And I will see you next Monday to begin that very lovely series I have in mind. Mwah!